Of course, enough. I know deliberation is going on, which in fact doesn't require. There are so many other things where we have to boil. I don't know where we are not boiling for that, but for CSR we have given such important this thing. In fact, we are more supporting to government in terms of supporting CSR. That's supposed to be a fundamental duties of the government. If you see the Constitution of India, it says it's a state function. The duties of the state that they have to give all that. They have to eradicate extreme hunger or ordinary hunger, whatever it is. They have to eradicate, they have to give the education, they have to give food. All those are fundamental duties of the state. Now completely it is shifted to the corporate. And we feel so privileged and discussing word by word of it, saying that how I can follow that. But there are so many things to follow. In fact, whole government and whole police are now police in the form of SFIO, Serious Fraud Investigation, who is going to take the complete charge of the enforcement of the act. Even in future, no police is going to come and arrest. A official of the MCA in the form of SFIO. SFIO is given a legal recognition now. So now, no police authority need to come and arrest a person inside the company if the account is proved wrong. In fact, the SFIO person, he can enter into the office if he could able to conceive that offense is taken or fraud is taken place into the accounts of the company, then he can simply take the officials of the company and produce before the magistrate. So the SFIO is going to step into the shoes of the police. In fact, I don't know, like a police station, how we have E1, E2, E3, like that we may be having SFIO 1, all this area wise, all this, I don't know, to go and enter into the company and inspect the records of the company and arrest the director and professionals also. In fact, he need not to file any complaint, need not to make the magistrate court to send summon to arrest a person. They have given an inherent power in the act by virtue of section 211 of the Companies Act 2013, whereby they can enter, and if they could able to find out that fraud is taken place in the accounts of the company, they can arrest the person and directly produce magistrate and get them punished. That level recognition is given to SFIO. So it's not that simply we can ignore something. There are so many other aspects to concentrate more than CSR. Of course, CSR, a single line is going to save us. If I am going to give a reason, then anyway, I am not going to be punished. Anyway, it is supposed to be a state function under the Constitution of India, but it is now shifted to the corporate. At least for relaxation, they have given that a saving class where we can give a reason and see that immediately we are not implementing. Somebody who is so interested, they can implement and help the state to improve. Though because the state is not in a position to do all the CSR activities, enough time is going on something else. So that they shifted that responsibility to corporate to do. So literally corporate are so generous, they can help the government by contributing to CSR and doing activities under CSR. And content of financial statement, not much difference between the private company and public company, but here the cash flow statement is become mandatory for all companies. That is a big change. In fact, under old companies like 1956 Act, there is no reference on that. But AS3, it mandates companies having turnover of 50 crores and borrowing of 10 crores. And of course, it is applicable to listed company. Even as per the listing agreement also, only for listed company cash flow statement is applicable. Now, there is no difference between private and public company. All company necessarily has to give a cash flow statement along in the financial statements. And the consolidation, of course, enough debate morning Mr. MP Vijay Kumar was giving. And I don't know, really it is going to be a big challenge only how it is going to be, but there is no much difference between the private company, public company here also. But the only challenge that we are going to face is consolidation is not only a subsidiary company, it is also joint venture. I don't know what can be deemed as a joint venture. That $1 million question. Government, as usual, they will come out with all spelling mistake. They will come out with the one-page clarification saying that joint venture can be. These are the parameters where you can take a company or a entity as a joint venture. Unless those circular comes, it will be highly difficult to understand and to deem a entity as a joint venture and to consolidate. At least subsidiary, there is a definition is in place where I can deem a company as a subsidiary if those parameters are the company falls in those parameters. But joint venture, there is no parameter prescribed, and we can't take clue from A is also here. There is the parent act. So we have to wait and see how the government is going to clarify on this. Of course, private company, public company, there is no much difference on auditor appointment. Of course, as we are aware that now appointment of auditor going to be 5 years, but every year there is a ratification. In turn, we are falling in square one only. Every year appointment only. If a resolution is failed, then new auditor has to be appointed. And the maximum number of companies now 20 only, and it includes now private company also for auditors. Signing of annual return, here also not much difference between private company and public company. Here they wanted practicing company secretary to sign the annual return of the company. I really don't understand how could, I don't know whether it's a drafting error or they have not taken it very seriously. For listed company, they want PCS to certify. For unlisted company, they want PCS to sign the annual report, annual return. I don't know what is the difference between signing and certifying. So then he is taking the responsibility of the company information. So he is responsible like another director who is signing an annual return. So it is, we have to wait and see how it is going to impact professional fraternity. General meeting, of course earlier there were so many exemptions was given. In fact, 173 statement, all this, generally we put a clause in the article of association where with that mentioning we take exemption for giving explanation statement under section 173. All this now taken away completely. Now no privileges available with respect to capital and meeting and whatever, of course except managing director remuneration, which I already told you. Simplification, what they have done, the only simplification done by bringing one-person company, that we have to wait and see really how we are going to get benefited out of it. But one thing I want to clarify here, there is no procedure to convert a proprietorship into one-person company. The company per se has to be incorporated as a one-person company. We should not get confused with one-person company. Immediately I can jump and convert sole proprietorship. How we convert a partnership? There is a chapter 9 in Companies Act where we can convert a partnership as a joint stock company into a company. But there is no provision under the new act to convert proprietorship into one-person company. So one-person company has to be incorporated as one-person company, and many exemptions and privileges are available to these companies, and based on capital and parameter and related party discussion. In fact, the only one benefit that the corporate corporate in India is going to avail is 297 and 314 implication, where every corporate and every professional would have find difficult when they cross the prescribed threshold limit, when they have to approach a central government and take approval. That is the only plus point in the new act, where they removed that government approval, central government approval under section 297. Now it is 188 under the new Companies Act, related party transaction. Same way that section 314 now got clubbed in section 188. Now provision of section 297 and section 314, office of place of profit, now got clubbed into one section called section 188 for related party transaction. There is not much difficulty. You have to pass a special resolution. It's far better than approaching central government and waiting for the approval, and till end you will not get approval. By the time person will resign and go also. Then after that they will put a query that why approval you have not taken. So now all those scenario is not going to be there under the new act. Now new act done away with all this government approval with respect to interested director transactions and office of place of profit. Board meeting through video conference. Here also not much difference between the private company and public company. And only one requirement is at least one board meeting the director should attend physically. That is the only parameter prescribed. Otherwise all other meeting can be done in video conference. Compliance certificate from VTS, of course now is going to be out of the scope of the Companies Act 2013, whereby they made alternatively annual return to be certified by a PCS instead of compliance certificate. And electronics mode, in fact everybody, whole corporate was feeling so happy that now accounts are permitted to be maintained under electronic form. I don't understand. In fact 2000 itself, Information Technology Act very much permit the entire corporate in India to maintain their accounts, whatever it is, whatever the document, whatever return, whatever the form, that can be maintained in the physical can also be maintained in the e-form or in the electronic mode. But since we have not seen any provision under the Companies Act, we always scare that nothing should be maintained in the e-form. No, for that to remove that scare, government has come out expressly. I don't know whether government knowing this they have come out or not, I don't know, but they now come out expressly that it can be maintained electronic form. Even other areas also companies are permitted to maintain their accounts in electronic form. And listed company, of course, not too much on listed company, we have to spend time. Now the definition of listed company alone, little we have to understand. A company, I'll just read for the benefit of the professional sitting here. Listed company means a company which has any of its securities listed on any recognized stock exchange. What is securities? It means securities are defined again class H of the SIRA. When you see the SIRA, security, it has got, it already, as it is an inclusive definition. Okay, and everything under the sky will be included. But as it is, further if you see, it includes shares, scrips, stocks, bonds, debentures. Fine. If a company lists its debenture alone in a recognized stock exchange, whether the company can be deemed as a listed company, whether that company will be mandated to follow all the listing agreement provisions, there is no answer for that. In fact, it's not that only shares listed can be deemed as a listed company. Now, by virtue of this new definition and the new act, where they made it that listed security, any company which lists its security may be anything. Okay, my shares are not listed, debentures alone listed, bond is listed. Am I a listed company or unlisted company? My shares are not listed. So this is going to be a scenario. Okay, fine, I am deemed as a listed company just for the sake of my debentures got listed in a listing stock exchanges. Fine. Then do you have to follow the provisions of listing agreement? There is no separate provision to be followed for company, those who are listed as debentures alone or bond alone. There are common provisions in the listing agreement which every listed company has to follow. There is no clarity on that. We have to wait and see the days to come how it is going to be dealt with. And listed company, of course, there are annual return, there is a certification is prescribed as it is in the old act also. PCS is required to certify the annual return. Same thing, not much change. We'll say the important change. Now they are more concentrating on shareholding pattern. As it is there for listed companies. And now again they brought it within the scope of the register of companies also. Who has to file the shareholding? All listed companies. Then what needs to be prepared? A report regarding change in shareholding when 15 days time, and there is a form for 7.10. Now all forms is point only. Now we can't be happy that okay fine we have now as of now in the old act hardly we have 10 forms only, I believe so. You can't list out tell more than 10 forms, but now we are going to have almost 100 forms. In fact, if for incorporation, if you start form number 1, that itself goes up to point number 1.21, then 2.18, 3 like that. We have to, in fact, we have to so strong in numerical in the days to come, and going forward, we should not be expert in law also, we should be expert in numerical also. Otherwise, we can't keep all the form in my mind, because we have to keep all the forms 7.9, 7.8 and 2.8, in fact 1.20, and I don't know, really we have to do lot of exercise. Along with our children, we can also read and memorize. That is the only way out. I don't think otherwise it will settle in our mind. And quorum for the meeting, again they brought some parameters. I don't know, government is taking every effort to ensure that corporates are regulated. But anyway, we'll see how, we have to wait and see. But the requirement is now 5 members if less than 1,000 members in the company, and 50 members will form quorum if it is more than 1,000 and less than 5,000, and 30 members if it exists 5,000. This is going to be the quorum in future. And what is going to happen, everybody knows, in listed company in India, now instead of 5 employees becoming member, now 30 employees will be becoming member of the listed company. Before the meeting, they will make employee as a member. That is going to happen. See, the real split is different. But the problem here is the governance should be within. It should not, can't be brought by an act. Always the corporate can find another way out. And it is going, this only going to happen. We have to wait and see. And voting by electronic mode. Of course, now 500 or more shareholders, they should provide option of providing electronic mean also. Good welcoming measure. And postal ballot they brought, of course there is no much difference between the private company and public company, as it is section 192A and our listing agreement, almost same thing only. There's only this thing now, they brought a new provision where ordinary business cannot be transacted through postal ballot. What are those ordinary business? Appointment of auditor and adoption of accounts and director retired by rotation. This is going to be the ordinary business. And all item of business on which a director and auditor has right to be heard. I really don't understand what it is. In fact, the old Companies Act section 284, where directors to be heard before his removal. Same way auditor, when he is removed, he should be heard before his removal. I don't know any other scenario, even a professor sitting here, if you have idea, you can share also. Except this provision where director is removed and auditor is removed, there is no other scenario under either the old act or even new act to be heard. I don't think so. So except these two, everything else can be done in postal ballot. And there are lists is there. Of course, we already aware. There is not much change in the list of the postal ballot this thing. And minutes. Importantly, there is a specific provision has come. It's applicable both to private and public company. Where now we have to minutes not only to the board meeting, for all committee meetings. Now we are mandated to maintain a minutes as if we are maintaining minutes for board meeting and general meeting. And maintenance and inspection of documents, of course, electronic form. We can move on. And this is the important thing which we have to understand. Report on annual general meeting by listed company. This is a new provision which has come under section 121. As it is for listed company, we used to give within a day we have to give a minutes to the stock exchanges for AGM proceeding. Now they brought us a kind of a report where they have to give all the details. In addition to the minutes only, they have to give all these details. This is additional parameter prescribed to the listed companies. Of course, they are giving more scope for us to prepare more report. And report on annual general meeting, again the whole continuation. Signing of report can be by any two directors. And board report has to disclose all this. And enough disclosure is taking place. In fact, our previous speaker, so how he says, same way we are going to have a bound book only. I don't think any single person except the printer. In fact, printer they said in terms of benefit they said. But I am telling in terms of even reading also, printer alone will read entire document. Because nobody else knows. For him, proofreading you have to read. Otherwise here, director's report anyway, no director is going to read. Only if a secretary has to prepare, he has to give and he is going to sign. Notice as it is. Accounts anyway, nobody else except an auditor and a CFO of a company. Who will have a complete idea of a whole document? Only the printer fellow. Who will read from first letter to last letter. Of course, he may not be capable of understanding anything, but the only fellow, he will be the fellow who know entire content what is inside without understanding what it is. And this is going to be much disclosure is there. In fact, we can have a disclosure seminar separately for that. And internal audit. Here we need not to spend too much time. The only point that we have to understand that they brought chartered accountant, of course, a statutory auditor outside the scope, and the cost accountant and other professionals. They said, I don't know, engineers, doctors permitted. That I leave to the forum. You have to decide because I don't know what stuff government to come out. Hardly there are 4-5 professional qualifications left out. Probably CFA and whatever you call it, CS. And I don't know what stuff government to come out with a list or come out in the rule. They left it as a professional. Whoever professional they claim professional. They can even courier fellow also now say professional only. I don't know they is permitted or not. And secretarial audit is a new concept which has come. We have to wait and see how effectively it's getting implemented by the corporate. There are threshold is given more than 100 crores. Very few companies only going to see the light of the secretarial audit, and other companies is exempted only. And board committees, there are a lot of committees has come. Nominee, remuneration committee, stakeholder committee, CSR committee, audit committee. And if you can suggest also some more committee you want to suggest to government, you can suggest, they will come that committee also. So end of the day we have to wait and see how the